Hey everyone, we're going to get started here. I'm going to stop the share for a second so you can see who you're listening to. I'm Ed Ronsman with McCabe Ronsman. This is Jim Roach. And then Lee, if you want to introduce yourself to everybody and kind of get us started here.
Sure, I'd be happy to. Good morning, everyone. My name is Lee Stokes, and I'm the Vice President for the Northeast and Orlando regions for Vesta Property Services. We want to thank you all for joining us this morning for this webinar as we all gather together to navigate the COVID-19 waters as managers, as board members, and as committee members for those that have joined us. Partnering with Vesta for this conversation is the law firm of McCabe Ronsman. McCabe Ronsman is a full-service firm with 7 attorneys representing community associations throughout the state of Florida. It is my pleasure to introduce to you now 2 attorneys from McCabe Ronsman who will be facilitating this discussion. First is Ed Ronsman, who is a partner and is board certified in condominium and plan development law. Ed has devoted his entire legal career to representing community associations throughout the state. Ed and I have worked together for over 10 years with our clients and providing educational seminars throughout the Northeast region. The second attorney is James Roach, who is also a partner with McCabe Ronsman, representing community associations and developers. James focuses on providing general counsel legal services as well as representing association in contested litigation. Thank you to Ed and James. We look forward to your presentation. And at that, I'll turn it over to Ed to kick us off.
Thanks, Lee. So for everybody, right before we get started here, one, I wanted to thank Kevin from Vesta for helping us get this started up and for Vesta for leading this charge, and we're happy to help present this. I did want to mention, because I did receive some questions, we'll be doing 3 of these in total this week for Vesta. Today is for the North region, with Lee as the VP for that region, but if you've signed up or if you're in a different region, that's okay, because it's going to be the same course. We're just dividing it out by each region. So if you did join and you've registered for Wednesday, feel free to stay, or if you'd like to come back on Wednesday, we'll be doing the same thing on the same time on Monday, Wednesday, and Friday. So I just wanted to be clear that we had that. And you can go to the Vesta website for any of the information regarding this if you have any questions, or we'll make sure to help handle that for you. So what we're going to do, a little bit of housekeeping. If you haven't used Zoom before, I know a lot of people are probably using it now for the first time. If you look for our attendees here, there's a Q&A button. What we're going to do is we'll be happy to take questions when we go through this, but because we have a lot of people here, I anticipate we're going to get a lot of questions, and a lot of them may be similar. And so what we're going to try to do is anticipate that a little bit, go through the slideshow that I'm going to be sharing with you, and then at the end, we'll see what questions that we have, and then we'll be happy to take them as time permits, and then if not, we can always help you offline. So I think that'd be the best way for us to get going. All right, so we're going to get going here. All right. So the topics that we're going to have for our presentation today, we want to talk about the association's responsibility regarding COVID-19 and your operating, your common areas and your facilities, altering, postponing, or canceling community events and meetings, whether or not you should update your cleaning and maintenance schedules, planning for possibility of shelter-in-place orders, and then assessments and financial difficulties, kind of what we see as maybe the more long-term effects for your community association. So some of the responsibilities during COVID-19, the role of the board generally is to oversee the maintenance, replacement, and repair of the common areas and facilities and the condominium common elements. A big question is, does this role require the board to prevent the spread of an illness or disease? And if you can imagine the liability that associations might have if it was your job to protect your owners from contracting any type of disease or anything else, you'd have to be out there scouring and sanitizing the property 24/7. I think that's a very difficult thing to ask of the association, and I'm not really sure that, and it's really not our opinion, depending on the facts for your community and how your documents are written, that you have an obligation to go out there and wiping down and making sure that everything is sanitary. I think that if you if you start communicating that that you will be overseeing this and making sure that everybody's safe, the main difficulty that we see from a liability standpoint is now whether or not you've undertaken a duty that you may not have had before. And so you obviously want to make sure that people are safe, and that, you know, we're protecting the residents. Obviously, that's why you maintain your common areas and facilities. If something's broken down, you don't want somebody to get hurt from it. But at the same point, I don't know that it extends all the way to double checking everything or triple checking or whatever it is and trying to actively prevent the spread of the disease. The best thing that you can do is have owners be smart and follow guidance from the state and federal level in terms of from the CDC, all of the recommended guidelines about social distancing, everything else is in place. It's not the association's job generally to jump in and to police that. I think people ultimately need to be safe and they need to protect themselves. If there is something that may be in violation of an executive order or something that's been put in place, it's really not the association's job to enforce that. It would be like anything else when we weren't going through this time period. If, you know, a question that we get is somebody's trespassing, what are we supposed to do? And our first answer is always call the police, right? And so if there's something that could be considered a criminal act, or I think now even with the executive order, for example, on the limitation of short-term rentals, for example, if you read through that, there's actually, it's a second-degree misdemeanor for advertising in violation of that. So some of these things, really the main thing is to contact law enforcement. Jim, did you want to jump in on any of that?
Yeah, so taking a step back, you know, as attorneys, we look through things obviously from a human perspective, but also from a liability standpoint. And what are some things we can do while navigating the COVID-19 situation in a way that also, you know, considers the potential exposure to liability? So one of which is a duty of any landowner, right? What duties do you have to people coming on your property? And in part in Florida, that depends on the nature of the person coming on your property. And just generally, you have a lower duty to trespassers than you do, for example, your residents or guests or actual unit owners. So one of the things that we have to keep in mind is understanding what your role is and trying to stay within that role. Should you be communicating to people about what governmental recommendations are with respect to, you know, social distancing and things like that? And should you discourage use of amenities, especially ones like, you know, gym facilities and so forth, where you have people touching the same equipment? Absolutely, you can certainly take common sense approaches. But at the same time, you want to not go so far and say certain things that, you know, someone could potentially argue that you've created a duty or an undertaking now to ensure the health and safety of your residents, right? So when you're communicating to people, you know, we recommend exercising caution and including statements such as, we as the board are committed to your safety and well-being, or things like that, like where you're undertaking a commitment, right? You can express sympathy for people without saying words that could be argued by a personal injury attorney later on to have created a duty for you to ensure safety. So like reasonable steps you can take, if you can increase your cleaning services, which is a point we'll get to later, sure, and you can absolutely take common sense steps, but just be careful in your communications. And what we'll get to a little bit later is we actually suggest including some disclaimer language, while not trying to seem too unsympathetic, but some disclaimer language in your communication to residents, saying that, hey, look, we're not undertaking any duty or obligation to ensure everyone's health. We will try to take reasonable steps that we can that are within our control to mitigate the spread of the disease within our community, but understand that every individual person has to take responsibility for his or her own health and needs to take actions that, you know, will mitigate his or her personal circumstances. So that's what we're getting at here. You can express sympathy, but also you have to keep in mind the potential for liability. Be careful with your communication to people when you're, you know, posting notices near your facilities, for example, or sending it that e-blast to the community.
All right, thanks, Jim. So a majority of the questions that we've been receiving are, what do we do with our amenities? What do we do with our pool, our clubhouse, our fitness center? And the question is, I think that it depends on your community, and that's a great lawyer answer, right? It depends on your community. And do I think that associations have the ability to restrict access to all the amenities? I think they do, and that would be under the emergency powers, which we've listed here. We may have a couple of cooperative members in here. That would be Chapter 719 of the Florida statutes, which are largely identical, and I'm happy to provide that if you want to email me if you can't find that. But you have emergency statutory powers. within, and there's a list of those that you can find. The main things, and we'll talk about the ones that are coming up the most, there are a couple of statutory powers regarding whether or not the property is deemed to be safe for habitation, and whether or not they can be occupied. And one kind of deals more with people actually living there, another is for the amenities being used. And so we're in a state of emergency that was declared, I believe, on March 9th, if I remember right. And so where we're at is you have access to those emergency powers. And then one thing that recently just came out is that the division, through the DVPR, there's the Division of Condominiums, Timeshares, and Mobile Homes. They issued an order basically clarifying that the emergency powers available under these statutes are not just for events caused by property damage. That's the way that the statute reads presently. And so they've clarified that. I think they actually said that they are suspending that wording of the statute, which means that the statute probably needs to be changed. And so really want to provide a kudos to Vesta, and to basically Vesta took the charge to lobby. They have their own lobbyists, went to Tallahassee and made sure that the some type of a clarifying order was provided. I had spoken with somebody from the division about a week ago, and it was kind of their informal position. And I think that the push, especially from Vesta through their lobbyists, to have this as an order that was clarifying it was really helpful for us, because there is a literal reading of the statute which says that these emergency powers are really only from events caused by property damage, for example. So you have the emergency statutory powers. In terms of closing down the amenities, we're not aware of anything. I know it would be all across the news if there was an order closing down all of the pools, for example, in the state, whether or not it's private residential for an HOA or even for hotels or anything that's more public. That hasn't been made available. So there is nothing in place that says that pools should close. If associations choose to do so, it would be under this emergency power. What I would recommend doing if you are going to do that is you are still required to hold meetings as a board right now during this time. You're supposed to give notice in a manner as practical as possible, and we're going to talk about the meeting notice requirements. You know, the statute says that you can deviate from the 48-hour notice, but that, in my opinion, really is in reference to if there's a storm event, if there's something coming up and there's a shift in the path of a hurricane, for example, and you need to call a meeting, but you can't give 48 hours notice, you're allowed to give it in as quick as manner as possible and in the best way possible if you don't think that posting is the best way, but you still are required to have meetings. So that leads to the next question, which is where we're really in uncharted territory. And I'm kind of moving in a little bit to the meeting question, which is, can you hold a fully virtual board meeting? There's nothing in the state statute and the emergency powers that specifically allows you to do it. However, I feel that it's very defensible if you are going to do that, where you would post the meeting notice and or you probably have an email blast and put it on your website. Provide notice as best as possible. That is provided in the statute that you're allowed to do that in order to hold a meeting under the emergency powers. And if you're going to hold a completely virtual board meeting, make sure that there's some type of a telephone conference line for people to be able to call into. People are still able to attend the meetings. You want to make it as easy as possible for them. But what I think we're going to see is an amendment to the statute in the future to cover where if it's not safe for people to actually meet in person. Of course, you know, if you call the board meeting, if you normally have 30 people there, it'd be very difficult to practice the social distancing, of course, with 6 feet apart and not having gatherings of more than 10 people at one time. So then you're left with a difficult question of, well, if we have a physical location, are we going to have a bouncer at the door, for example, keeping people out once we hit the maximum number? So I've been advising clients that if you are at least advertising and noting that the meeting is going to take place and that you provide a telephone conference line of some sort, that any action taken at that would be defensible. I have a hard time finding a judge or an arbitrator finding that any action taken is invalid because you're supposed to have some type of physical location for people to be able to show up. When it's a board meeting, the board is the entity that is able to vote, and there are statutory rights to appear telephonically or by FaceTime or anything with live presence. So I think the fact that as long as the board is there and the board is the voting entity for anything at a board meeting, of course, I find that more defensible than, for example, the annual meeting, which we'll get into in a little bit. But in terms of going back to the common area restrictions, I think it is something that is a lot easier to do, and we've seen a lot of communities that have closed down their fitness centers because it's in a closed space. You have people using the equipment all the time, and it's really tough to obviously keep that sanitized, keep it safe. But the open air pools are a more difficult question because of the fact that people could technically, congregate there without being in violation of the social distancing, recommendations, I guess. And so I think that's largely a case-by-case basis for your community. I can't tell you whether or not you should or shouldn't close down your pools, for example. Jim, do you want to add anything to that?
Yeah, I think some facilities are pretty intuitive. Gyms especially, anything where people can be in close proximity to others, I think are relatively no-brainers. Things like pools, I think, are going to be on a case-by-case basis depending on your specific community and how that facility is arranged in your specific community. Going back quickly to board meeting things, whether we can rely on the emergency powers and the statutes under certain circumstances could be a little bit subject to debate. Try to provide notice the best you can. A couple of other things that you can do is delegate some more authority, some executive authority to your boots on the ground. In other words, maybe your president lives there, but some of the other board members don't live in the community, and your president has the ability to see what problems are happening or what issues might be occurring in your community. So consider as a board delegating some emergency powers, internal emergency powers, or decision-making authority to your officers. And maybe that's the president, or maybe the secretary is the best person. It depends on your community. So consider delegating some authority to some boots on the ground. And ultimately, if we ultimately get some issues in terms of how you've made those decisions or whether the board meeting was noticed properly, we can do some things on the back end like ratification to help you become, or your position become, a little more defensible. But we think that there should be room to get a little bit of a pass or a little bit of an excuse for associations trying to make decisions in these difficult circumstances, whether those excuses or defenses come from the Emergency Powers Act or just come from the practicality of our circumstances. But the long story short is consider delegating some more executive authority if you don't think you're going to be able to meet as a board, whether it's remotely or otherwise in the interim. So for example, you might say, hey, we as a board, we're going to vote to give our president the authority to make the decision of how long our facilities are going to be open for. And of course, you as the board can always take that authority away later if you want to. But that's some of the ways that you can sort of get around these technical requirements for meetings by delegating some authority in a properly noticed board meeting, or to the extent that you can, until some of this dust clears with COVID-19. And again, we can always do ratification after the fact as well.
So just a technical note, some people are chatting or sending questions that maybe the audio is cut out. I don't have a good answer for it. It looks like it's working on our end. I will try to mute my audio and then unmute it in case that might help. You can always try to jump out and then jump back in. The other thing is that we're also recording this too, and we're going to make sure that that can be made available to you in case your audio cuts out. So I'm just going to mute it and then unmute it real quick. All right. Okay, so going through this, again, common area and common element operations, and what we're going to be doing with the property. For communities that have chosen to leave their amenities open, they've posted maybe some of the available flyers from the CDC website regarding how to spot, symptoms of coronavirus, what are ways to stay safe with it. And you can strongly recommend, but if you are to still keep it open, you may just choose to go that far. Again, it just depends on your community. But look, I understand. I have 4 boys that are not in school right now. I understand that people have families and that people aren't able to really go anywhere. So I completely understand wanting to keep the pools open. I think it depends on how your community, and if anybody's in St. Johns County, there was a picture that went viral over the weekend, and I'm not sure if you saw that, Jim, but you could tell Duval County has closed down public access to the beaches, but St. Johns County did not. And you could see people where the line was from Duval County versus St. Johns County, and all of the people in St. Johns County all crammed together along that line, probably where a public access spot was. And that made the national news. And then once that came out, I don't think it's a coincidence that an hour later, St. Johns County issued an order that they were closing all public access and that the beaches were closed. So if you're having that problem with your community, with people at the pools, I would say talk with your manager and talk with your attorney about maybe taking steps to look at amenity closures. But again, it's not a clear black and white answer. It's a tough one. Yeah, go ahead.
Yeah, and if you do keep them open, consider posting a notice, sort of like a disclaimer notice, in addition to the CDC flyers and things like that, which are good information. Basically, a use at your own risk, right? A notice simply stating that these facilities, you know, they're only being cleaned to a certain level or a certain frequency, and basically informing people that they're using these facilities at their own risk.
So I'm going to answer
to warn them.
There's a good question right here that just came in, and I'm going to answer it, which is, does closing a pool because it was overcrowded create an expectation of additional oversight by the board or other community areas and therefore additional liability? I think it's a great point. I think there's a tough line to walk between, you know, you're so worried about liability that the board takes a hands-off approach on everything because you don't want to make it seem like we're establishing some type of duty for us to oversee everything. But you also, in real time, you want to protect your residents as best you can. So I think there's a fine line of doing it, that if you do choose to close down the amenities for some reason, you would express that it's through the statutory powers that the association has, that you still put that kind of disclaimer language that it's still not, you know, you are responsible for your own health and, you know, make the best decisions for you as possible. But due to overcrowding or something like that, we are taking this position that we're going to be closing down the amenities until further notice. I don't think there's a perfect answer on it. I think you can go either way where, like you said, if you don't do anything and allow people to use everything, you could have an instance of it spreading throughout your community. If you close down everything, then there may be an expectation that you're undertaking the duty, and people are going to be upset if they aren't able to use amenities that they feel should be open. So I think you need to work through it on a case-by-case basis with your community and kind of judge it. And again, talk with your manager and attorney as to what the best route is for you to go. All right. So emergency powers for common areas and property, we've touched on a lot of this. The main thing though, and when we've been asked for an opinion, is that the statute says that you can deem a portion of the property or the property unavailable based upon the advice of emergency management officials or from a professional that's retained by the association. And probably most of you haven't understandably gone through hiring somebody specifically to give you an opinion on what you should be doing with your amenities. I think you may be able to do that. And if that person provides you with an opinion that I think that this area is unsafe for occupancy, again, that may be a way to do it. I'm not sure if a professional is going to be willing to provide that opinion when it's not. That, again, this is more related to property damage after a storm, or whether or not the debris needs to be cleared out, if it's safe for people to actually get to their property and use it or not. I don't know that it's kind of uncharted territories again regarding using it when it's in the face of some type of a pandemic like we're facing right now. But those are the two conditions. And so when I mentioned before about there hasn't been an order, for example, closing down pools, that would be where, if there was, you could rely upon emergency management officials coming out and saying, hey, we recommend that anybody with a pool for anything outside of a single family residence, for example, like a community association or anywhere else, that it's, you know, if they found that, for example, it was easier to contract the disease because of people swimming in the pool and it was transmitted through the water or something like that, which I don't think it's been provided to us that that's been the case. That may be an easier way for you to decide to close down. But if we don't have that, that's where it makes it more of a game call decision for your community based upon how people are using it and what the board feels like it wants to do to try to keep people safe while not undertaking unnecessary liability there. So those are the two things: determine any portion of association property unavailable for entry or occupancy, and then determining whether the association property can be safely inhabited or occupied.
If I could jump in really quickly.
Yeah, go ahead.
We think that you're likely going to have a defensible position closing down things like amenities, but we're not suggesting at this time that you try to deny access to anybody through any common element portions of a condominium, for example, a condominium building, so that they can get to their units. You know, we're not suggesting here that these powers should be used at this time as an opportunity to sort of shut down the entire community and kick everybody out. I think that pretty much goes without saying, but you know, we've had some pretty, I don't want to say aggressive questions about closing other areas aside from common areas in a condominium. So don't deny people access at this point under the emergency powers or otherwise, right, to their units.
There's a good question here. I'll answer it real quick because we're dealing with this from Marshall. Could you share a ranking of risk of items in common areas, drinking fountains, toilets, bathrooms, tabletops, pool hardware for access, entrance gates? You know, I think that what we mentioned before, like fitness centers enclosed, anywhere where it's more of a closed amenity, like a gathering space where it's more likely that people will be closer together and not being able to abide by the, you know, crowd gatherings of 10 people or less or the 6 feet of social distancing. I think that's an easier decision to make of closing it down. Drinking fountains, I think I understand that completely of whether or not you wanted to, you know, if you wanted to suspend use of that, I'm sure you could probably manually turn those off at some point if that's a way. Again, it becomes one of those, it kind of snowballs a little bit where the more that you're closing down and making it look like you're undertaking the duty to protect people from the spread of it, the more if somebody contracts it, they can say, well, you did this, you took this step, why didn't you take this step as well? And that's the difficulty with all this. You know, Jim and I were talking about this previously. If any of you live in a CDD, I've noticed that many CDDs have closed down all of their amenities. Anything that basically requires some type of a gate or door entry, I've noticed that the CDDs have closed that down. You know, there may be some argument there as to different duties that they may owe as a kind of a quasi-governmental entity as opposed to a private homeowners association. That could just be the decision that they've made and will risk any type of, they'd rather protect, I guess, people from not being able to use the amenities and having challenges from that than some type of an argument being made that they, you know, help contribute to the spread of some type of the virus or something like that. But again, I think that common sense, you might look at what are the more higher use areas. If you see people that are still using it, you might react to it on a case-by-case basis, I think is the best way to answer that one. All right. So I'm going to keep going on. Let's see here. And I know we have more questions, and we'll be happy to try to answer some more of those at the end, everyone. Again, case-by-case basis. Many factors to consider: the health and safety of the residents, potential liability of the association, and the right of owners and guests to use the amenities. For example, I represented one community. There was a question about why the tennis courts were shut down as opposed to maybe the fitness center. I can understand maybe the tennis court being some type of an area where it's less likely that you'll have more than a couple people there anyways. And maybe if you allow that to stay open, you just put another sign up saying you use it at your own risk. It's not like we're coming out and wiping down the door handles after every time somebody opens and closes it. So that a tennis court might be different, for example, than a small fitness center. I know I keep using that, but that would be, to me, the easiest place for people touching equipment and holding on the handlebars and that kind of thing, as opposed to more of an open air amenity. So communication with residents, consider an e-newsletter or an email blast with the status of the property, the amenities, just communicating with your owners as to what's going on. Again, you see this constantly that we've been talking about today, advising owners and guests that the association does not guarantee the health, safety, and welfare, and that any use of the areas and facilities is at their own risk. But you need to continue to have board meetings, and notice can be provided by alternative means, which we talked about before. So membership meetings, this is under the emergency powers. Membership meetings may be canceled and rescheduled. One question that Jim and I actually debated was the postponement of meetings. If you've already sent out your notice for your annual meeting and you're decided to postpone it, is that allowed per the statute? The statute says that they can be canceled and rescheduled. I've been of the opinion, and we're seeking guidance from the DBPR. They have not issued an order on this right now. What I've advised some clients is that if you have sent out the first notice, for example, if you have an annual meeting coming up, you've sent out the first notice, and you have a call for candidates for your election. This is especially for condos because you all have the same type of election process. But if you have an HOA that has a similar process where you have a first notice, a call for candidates, and there's a cutoff period before you send out the second notice, I have advised some clients that I think that it would be defensible to postpone that meeting, let everybody know that we're not going to hold it on the date originally planned. We have all the candidates that have put their name in. We will renotice it or send out the second notice with the alternative date and time once we have better information as to when it's safe for us to have a meeting, for example. There's some questions as to that. The statute says that the first notice and the second notice have to have the same date, time, and location, and the statute doesn't say specifically that you can postpone it. I think it would come under the definition of whether or not canceled and rescheduled means you have to completely start over, or can you reschedule it as part of the resending of the second notice, for example. The difficulty though, and one thing that I've, in going into the virtual meetings is whether or not you can have a completely virtual annual meeting, for example. And while I said before that I could see having a completely virtual board meeting, that's because I think that the board members are already allowed to participate virtually, even if we weren't in a state of emergency right now. And so really from the membership standpoint there, it's to observe and then to make a comment on any agenda item. Whereas the annual and membership meetings that is a member meeting. That is their ability to show up, and you typically provide more leeway for owners to make comments or have almost like a town hall type meeting. And then of course, if there's an election or some type of vote, the members are actually the ones that are able to vote. And so what we've been advising clients is there needs to be a way for them, if they don't vote electronically, if you haven't gone to electronic voting yet, or if they haven't sent in their proxy, there should be a physical place for them to be able to show up and cast their ballot at the date of the meeting. And so that's why we've been advising associations for the time being until we get maybe further guidance we have to think about if that would be permissible even, from the division to be able to add an emergency power, for example, to not have a completely virtual annual meeting. One of the problems is, you just think about it from a physical meeting location. I know a lot of communities that I work with they don't have the facilities on hand, so they will either rent out like a clubhouse from another community, like a CDD, or from the management company, or they'll rent out some type of commercial meeting space, for example. And everything we've been seeing, that has been closed down. So even the actual ability to have the meeting is very difficult. I work with one community where they've taken the position that any mail that comes in is kind of in a 3-day quarantine period anyways. I'm not sure how they came up with 3 days specifically, but they have kind of a waiting process for mail that comes in before it's actually processed. So you can see how that would be difficult if you were trying to accept ballots the day before the day of the meeting, if some communities have put that into place, for example. So I think the physical location aspect is hard. Most communities we've been advising postponing it, or to be completely safe under the statute, you could restart the meeting process and send out the first notice again. The statute clearly allows you the ability to do that. I would just, again, talk with your manager and talk with your attorney about if you don't want to resend the first notice, if you've done that and you have that method of communication for your annual meetings, or whether or not you want to postpone it and kind of freeze everything that you've done so far, and then just be in a waiting period before you send out the second notice with the new date, time, and location. Jim, did you have anything else on that?
Yeah. To sort of summarize, could we think of some potential ways that you could hold a membership meeting depending on what your governing documents say, particularly in an HOA? Sure. But we think right now, probably the best and most conservative thing to do is to postpone it and then provide notice to people and, recommence the annual meeting process once some of this dust settles. Again, we could, potentially look in an HOA specifically, you have a little more flexibility and it's more governing document dependent in terms of how you conduct your annual meeting and election. But many of our associations, we're not finding enough flexibility in their governing documents to address this type of situation. Perhaps we'll see some help from the legislature and maybe adding some more emergency powers in the future. But for now, the most conservative course of action is to not have an annual meeting where you're going to have people at least with the opportunity to physically interact with each other. So postponing for now and then picking the process back up again at a later date is really what we're suggesting. Now, whether that requires you to, for example, renotice the first notice if you've already done so in a condo, there's a little bit of room for argument. But what we're probably gonna come down the side of, if you've already sent your first notice, if the candidate process is already concluded, particularly in larger communities, that could be a pretty big mailing expense. So we're likely going to say, hey, let's pick up the ball where you left it off before. Let's kind of postpone and stay things for now. And if someone wants to challenge that and the board's decision later on to re-pick up that process and not incur all those mailing expenses in the future, first of all, they have a very short window to do that. It's going to be within 60 days of the election. And second of all, hopefully people will have some common sense in your communities, although we might not have jobs if that were always the case. But hopefully they'll understand that the board's doing what it can under the circumstances, and that ultimately, if the process is fair, the membership will be willing to accept the fact that it had to be postponed for a little while.
Yeah. And I see there's some good questions in here, and there's some good comments in the chat. One thing, just real quick, more of an informational thing. It looks like in Pinellas County, the sheriff on March 26th said that all swimming pools located at hotels, motels, lodging establishments, condominiums, and commercial business establishments, as well as HOAs, shall be closed. So that would be something where you can look at least if there's always a question of authority to issue these type of orders for private property, for example, but let's just assume that that's all valid, and I think we can probably safely assume that. That would be something that your community could then rely upon under the emergency powers, where it says based upon the advice of emergency management officials. That would be something very clear. So obviously keep track of your local, your municipality, your county, or your city that you live in to see if they're issuing any specific orders. You want to make sure you're in compliance. From a state level, there hasn't been anything issued like that, so you want to keep track of your county. There was a question too about Alachua County closing all public pools. HOAs use this as an example to why they should close their pools. That's a good point, but the question is, are county mandates? If it doesn't say specifically, if it just says for public pools, HOA and condo pools are not public, so that wouldn't be applicable. Now, could you use it as an example? I think it could be a reasonable basis, even if it wasn't directed at your community. I think that would be a reasonable basis for you to choose to close, even if it might not be legally required. Let's see. All right, so we're going to go through just some more of the slides, and then we're going to get to some of the questions at the end, if that's good for everybody. Cleaning and maintenance schedules, we've kind of touched on a lot of this. Board has discretion whether to increase cleaning and maintenance schedule. Somebody posted in the chat, I just saw too, that I wanted to mention that this virus can stay on surfaces for days. So of course, it's very important for people to be safe in what they're touching and don't feel like, well, there's, if statistics come out that there's a downturn in my community, don't automatically assume. I mean, this stuff can stick around for a while. I thought I saw something in the news that somebody they could transmit it like within over 30 days or something like that. Even people could be transmitting it. So I think we're in this for a good period of time, but I think the board does have discretion. So the question is, if you're already providing for cleaning and maintenance of your common areas and amenities, do I think it's appropriate, or I should say appropriate, but do you have the authority to increase your cleaning schedule, for example? I think that's certainly within your authority under the documents, and it's a proper common expense. Again, you want to balance the line between administering your duties under the governing documents and then warranting the safety of your residents. So just as long as you're not communicating something that we're here to protect you, we're on top of this, we're going to make sure this isn't transmitted, that's where you can come into difficulty. I know we're sounding like a broken record, but it's the method of how you're communicating this to your residents that we're really, you want to educate people and help them be adults and make good decisions, or if they have children, of course, be good parents or guardians to watch over their children. But we want to provide that information, but not make it seem like we're warranting everything for everybody. Again, considering disclaimer language, somebody had posted something that they had removed some of the pool furniture to make it less likely that people will congregate. I think that's fine. The question is, do you have to post signs? Again, I don't think that you have to, but I don't think it hurts to say, if you're keeping it open, use at your own risk, but we recommend that you read all this information about the spread and everything like that. I know we had another question. I'll go through and click it out later. If you see a bunch of people playing basketball, for example, I don't know that there's going to be much if you wanted to say something, you can say, hey, we post a rule, or you guys should be aware of this, that there's this, limitation in place, of course, the 6 feet of social distancing. But aside from that, I wouldn't insert yourself too much in it. All you can do is give people information. It's not your job to go in, and I would not go and try to physically break up a basketball game. So just be mindful of that. You can always use that as a way of communicating. Maybe if you're seeing use of amenities, if you're keeping them open, if you're seeing them being used in a way that's not in accordance with what the recommended procedures are in terms of large gatherings and stuff like that, continuing to send out maybe notifications saying, hey, we've observed this, please, you're reminded that be safe and protect each other. You're strongly recommended to only use this under these circumstances if you're going to keep them open.
Yeah, and you reminded me of a good point in terms of communicating with people. We're getting a lot of questions. Some of us here in Florida have lots of friends coming down from the north, and some of whom there might be some speculation that they may have been exposed to the virus, or in an area where it's maybe been more has been more concentrated. So I say all that to say this: it's okay to communicate with your residents, but be careful in what you're communicating, that you're not accusing people of having a disease if you're not confident of it. We just basically say, if you think someone may have been exposed in your community, you can say just that. But we're not saying, hey, John Smith in Unit 202, avoid that guy because he's got the coronavirus, right? First of all, you may not know whether that's true, even if you are relatively confident. But again, putting on my liability hat as an attorney again, accusing someone of having a disease where they don't could potentially be actionable defamation. So rather than targeting anyone or saying, hey, Unit 202 is a quarantine unit or saying things like that, just say, hey, we're trying to communicate with residents, so each of them may take measures they deem appropriate to ensure their own health and safety. We have reason to believe that someone may have been exposed in our community. Again, please observe social distancing and other governmental recommendations, so on and so forth. But what I'm not doing is targeting a specific individual who I believe might have it, even if I'm relatively confident. So don't call people out by name or any other identifying information. You can get the point across and information across by speaking more generally or writing more generally in your communication.
Okay. All right. Shelter-in-place orders. Be mindful of anything that comes in. There isn't anything that's mandated right now. Obviously, everybody be aware of from a state level. There have been additional information. I'm sure if you all got on our cell phones this weekend a recommendation for anybody, I think it was 65 and older, or with any pre-existing medical conditions, to stay indoors as much as possible while we ride this out. But be mindful, especially, it seems like this might be coming more from a local level. Of course, if our governor issues something like other states have, you want to be mindful of it. Again, considering the status of the amenities during that time, we would want to see what the text is and what the recommendation is from any entity that's issuing the shelter-in-place order to see if that provides further guidance for what your community should be doing. And then contact law enforcement if there's concerns over violation of any shelter-in-place order by your residents or guests. And don't try to insert yourself on something that law enforcement can be called out. Or, the question that's come up is, what do I do if I feel like somebody maybe has this and they're not self-quarantining, or if they're coming from New York or New Jersey and they've driven down and you see their license plates, for example. The best you can do is provide them with the recommendation to self-quarantine, and then and Jim, let me know your thoughts on this, but my thought would be contact your local, any local or state health agency to let them know and see it, and let them take a look at it some more. But from the standpoint, everybody's overloaded right now. And we had some questions from, is there something that we can do as an HOA? What can we do legally? Our state courts are largely in a necessary hearing only. It's not called that. It was an emergency hearing only, and so that's
essential and critical.
Essential and critical, which has basically been limited down to mostly 95% criminal, right? From all of the necessary criminal hearings that have to happen. It would be very difficult to get in front of a judge right now anyways, for example, and say, hey, judge, we've got a bunch of people congregating around our pool. We've closed down our pool, but they're still there anyways, and then law enforcement won't do anything about it. Unfortunately, I don't see us getting an order from a judge issuing what's called an injunction preventing them. They're closing down the court system for the most part, and it would be difficult for us to do it. The only thing that I can think of, and this is what we've talked about from an enforcement standpoint, that might hit their pocketbook at some point, is if the board met to put in place certain rules that might match what the recommendations are regarding social distancing and not more than 10 people, and make that an actual rule of your association, and then find that to be a violation and then going through the fining process. And if you all might be aware of the whole fining process, which is where the board imposes the fine, you send out the notice at least 14 days in advance, where the committee's going to meet and the committee imposes the fine. The question then is, well, what if our committee doesn't want to meet in person because we have this issue going on? It's a good question. I think the best we can do is document it. And if it's a repeated violation, if you have a rule in place specifically, then I think that would be grounds for us to send out violation letters later and to let them know that this might be subject to a fine. I'm not saying that would be, it would be interesting to see what arbitrators or judges do in enforcing fines for people that were using the amenities during this period. But I think that's your best method right now of trying to enforce. Again, there's some difficulties with it. The best thing you can do is just try to communicate as best you can with people to be safe and to be mindful of what's out there from a state and federal standpoint. Jim, do you have anything else?
Yeah, and of course, the fining and other enforcement tools, it's not going to stop the problem right now. And like Ed said, it's very difficult for us to get to court. But here are a couple of bullet point sort of takeaways. You might have a provision in your governing document saying that everyone has to comply with law generally when occupying any portion of the common areas or condominium property in a condominium. So you might have an indirect way to have some enforcement authority over that. But what we're not suggesting is that you get in a situation where you're confronting people personally, in addition to just having to personally interact with people, which is generally not recommended right now. Law enforcement has a job. Let law enforcement enforce laws. Don't all of a sudden become the sheriff in town. If people aren't listening, call other authorities. Call local law enforcement. Call the Florida Department of Health, particularly with the recent executive order mandating actually that people in the tri-state area self-quarantine for 14 days. If you think people aren't complying with that, that's not your opportunity to go knock on their door. That's somewhere where you're going to want to contact law enforcement and the Florida Department of Health. Might they do nothing? Yeah, that's absolutely possible that they'll do nothing or they'll be too overwhelmed. But that doesn't mean that we think that you should start knocking on doors and pushing people into don't all of a sudden become the sheriff in town. Still keep your own distance. And if you're seeing that use of amenities, people aren't complying with your policies that you're setting in place temporarily for this, even if they're trespassing or whatever the situation may be, sometimes you have to play to the lowest common denominator in these types of situations. So that might ultimately mean that you have to close those facilities altogether if you're not getting people complying with those policies. So turn the key, walk away, contact law enforcement if there are people that aren't that are violating governmental orders and mandates.
Right. So let's see. So the last slide, and then we'll go into and try to answer some of the questions that haven't been addressed already, are assessments and financial difficulties. So what we see as a long-term aspect, and this is more, it's different from the emergency powers from the standpoint of it's more looking at the state of the economy. Everybody, I'm sure a lot of you have seen what the unemployment, people filing for unemployment last week, the numbers came out, I think it was 3.3 million. And then the last reporting period, it was at 250,000. And so I don't know how frequently that happens, if it's every 2 weeks, every month or something like that, or maybe a different frequency. But obviously what we're going to see is some type of impact, of course, from a financial standpoint, which is people are losing their jobs and they are going to have difficulty paying their HOA fees. I don't think there's any way around that. I think that the stimulus bill will hopefully provide some relief, and this is not going to be a political discussion by any means, but there's obviously it's the largest stimulus bill. I mean, I think 3 times as much as what the last one was, if I remember right. It was 2-point-something trillion versus the $800 billion amount. So we'll see how that impacts it, but I think you're going to find a lot of your residents that are going to have difficulty depending on the type of industry that they worked in. Certain industries are hurt more than others. And so where that's leading to is, what do we do for people that can't pay their assessments? And I think the biggest thing that we want to caution against is trying to make a blanket statement on delaying collection of your assessments or delaying when the assessments are due, because that will quickly hurt your community. Throughout all this, you have contracts in place. You probably have some annual contracts or ongoing obligations where services are going to still be provided, and those vendors are going to be expected to be paid. I mean, and that's what the difficulty is throughout all this. And so I would say if you are receiving issues from owners, if they're contacting you, what we've been advising some of our clients is take a look at maybe suspending the late fees or interest for a certain period of time, whether you do that for all of your delinquent owners, or if you look at those on a case-by-case where you can see that it's a result of basically a loss of job. Somebody that's been delinquent for a year, this downturn isn't, that's not causing them to be delinquent. They probably were delinquent for some other reason. But if you see that people, for example, stop paying their dues on April 1st, for example, that's probably a good sign that people have been impacted as a result of this. And so the more that you make it specific, the more that you just have to be careful that you're treating everybody uniformly and you're being very objective about it. But I'd be very hesitant. In fact, I'd caution against anything regarding giving people a break on paying their assessments. There's actually something in the statute that says that you're not allowed to waive collection of assessments. So what we do is when we talk with our clients about this, when there's a foreclosure, for example, I think there may be a way from a business judgment standpoint, but we always say, look, you have late fees and interest. Those are your soft costs, for lack of a better term, where you didn't actually budget for it. It doesn't result in a corresponding out-of-pocket expense from the association. That's what you have to work with owners. can you extend, maybe have some type of payment plan for the assessments? I think you can look into that. But I think everybody should be considerate of what's going to happen. And again, walking the line between being empathetic and understanding that people are going through a difficult time. But also, if you have 25% of the people that stop paying their assessments all at once, that's going to drastically impact your ability to provide services, to pay your bills on time, to pay your insurance premiums when they come due. And so I wouldn't make any type of declaration as to what your assessment policy is going to be. I think we need to treat that on a case by case. And when owners contact you, if you have enough of them, maybe there is some type of resolution from the board that for anybody that becomes delinquent from this date, they need to contact the board and we will consider suspending late fees and interest, or if a payment plan is required or something like that. But the biggest thing is, don't provide something saying, hey, pay us when you can, or we'll waive this for the next quarter. You can obviously tell how that would be difficult for communities to survive doing something like that.
Right. So in general, we're cautioning against any kind of blanket communication purporting to suspend assessment payment obligations or prospectively waiving assessments, late fees, or interest. If you're getting concerned communications from residents, just say the board understands the circumstances and will consider, what it can do in response to people who are experiencing financial hardships, and they'll consider those on a case-by-case basis. Right now, just communicate generally. But what we want to avoid doing is, look, if they're not paying their HOA fees, they might not be paying their mortgage either. And if the mortgage company beats us to the punch in terms of foreclosing and collecting the, assessments or whatever is owed, we might ultimately be giving waivers that only benefit a financial institution that forecloses later. And we don't want to do that. So we want to preserve the ability to help people with good faith financial hardships that were caused by COVID-19 without giving a blanket statement that some bank or financial institution is going to have the benefit of later on down the road. So right now, just communicate vaguely and generally to people that we understand people are going to have financial hardships, but don't send any binding communications on yourself as the association purporting to waive or suspend anything at this time. We think looking at it at the back end when you get communications later on, when some of this dust settles, is going to be the way to go. And we anticipate that, in these kind of financial crisis times or these kind of economic hardship times, whether it's caused by this type of situation or another, we might have government intervention here saying, hey, for the next 120 days, there can't be any more foreclosures, or they're going to put a foreclosure moratorium. It's been done in the past, and it raises interesting constitutional questions. So right now, let's collect what we can while we can. The delinquencies we're seeing right now are probably not COVID related. It's probably something that you've had, a delinquent account before preceding this situation. Collect what you can while you can now. We'll see what we can do for people on the back end and avoid sending any kind of blanket waiver of communication for right now.
So I'm going to answer a question here that's a good one, and it ties in with another point I wanted to make. The question was, can we stop funding the reserves in anticipation of the job loss? There's nothing in the emergency powers that allows you to stop funding reserves. And so that's one thing. I could see there being some changes to the emergency powers statute, probably regarding meetings and holding meetings when it's not safe to meet in person. And I also could see something maybe coming out about the use of reserves, for example, if for operating expenses, maybe under the state of emergency. That's not there yet, though. And so you need to continue to fund your reserves, because you could be, if you're a condo, for example, you could be fined. There's an investigation that could be opened by the DVPR. Not saying that they're going to jump on that. That might not be their highest priority if you're using it for the purposes of helping people out, but you have to continue funding reserves. You could always vote to amend your budget and provide the appropriate budget notice. And you have to then have a membership vote, though, to waive or reduce the reserves than less than what the fully funded amounts are. And that requires membership approval. It's majority member approval at a meeting where a quorum is met. So it's not of your entire membership, but it's of majority of the members that are appearing at a meeting where a quorum is met. So it's a little bit lower threshold there. But for the time being, you have to make sure that you're fully funding your reserves, that that's the budget that you passed, and you're not allowed to use funds from reserves for operating unless you go and take a vote to use it for other than their intended purposes.
A vote of the membership.
Yep. Another question from Mona. It said, our community is about to vote on an assessment for new roads. Should we postpone? Again, that I wouldn't say if that's necessary for your community. I think you just have to determine the type of community that you have. If you're receiving communication from owners about whether or not there's going to be a financial hardship, but if that's something that you need, I would continue to go forward with it. And if somebody needs some type of an extension or request on paying that assessment, the board takes that up on a case-by-case basis, but I wouldn't stop anything that's necessary from a maintenance or repair standpoint that you are planning on doing right now. If it's not necessary, if it's more optional, if you can delay it a little bit based upon advice that you've received or something, certainly I could see you doing that. But if it's something like, hey, we really need to get this done and we've been working on this for a half a year and we were just about to take a vote, if it's a necessary item, I think you would continue on with it. That's what I would recommend.
Yeah, from a practical standpoint, you might not have enough people to participate depending on what your documents provide and how many votes you need. So that's more of a practical issue necessarily than a legal. Legally, could you consider proceeding? Sure, but practically, will you get the vote you need? Maybe not. So you might be forced to, adjourn and continue that meeting or otherwise postpone it if you're not going to get the participation you need to approve the assessment.
Yeah. So that's pretty much what we have on our slides for today. I'm going to go through and try to find some questions, and my apologies if I can't get to all of them. But let me see, there was a question at the end here that I would like to address, which was, if the board shut down the amenities without having a board meeting and communication, can a resident deduct the usage fees from their dues for this time? No, don't. I would advise against any resident that tries to do this. There's a case on point that I would think that would apply, which is an owner stopped paying their dues because they had water intrusion into their unit, and they were arguing that, well, if my dues goes towards maintenance of the common areas and the amenities, and the board's not doing a good job, I'm going to stop paying until they get their act together. It's kind of a similar type of situation. The response from the appellate court on that, which was, you have to keep paying, and if you feel like there's a violation or something that you were damaged by it, then you have to file your own separate counterclaim. If there's a lawsuit, you can file your own lawsuit against the association. So owners should not deduct any of their assessment payments if they feel like the board did something improperly. Again, as a reminder though, try to, you want to continue to have a board meeting in whatever way is possible. The statute just says that the rules on the notice requirements are lax if you have to have it sooner rather than later. Because of where we're at right now, unless there's some late breaking type of order or something like that, which requires immediate action by the board, you should try to provide your 48 hours notice. But if it's something where, okay, this is a mandate from our governor or from our county or something like that, and we need to then, we're going to mirror that because we need to shut it down. Let's call a meeting, let's give 12 hours notice or whatever it is as best as you can, blast it out to everybody, post it as you normally would. The statute would protect you on that, but you still need to make sure that you're having your meetings.
Yeah, and again, that's one thing you might be able to anticipate by having your board delegate some more executive power to the president or whomever might be best suited in your association for handling it. So for example, you might meet now while you have a little bit of luxury of time, at least seemingly as we're sitting here, say, hey, we as a board, we make a motion to delegate authority to the president to take action he or she deems reasonable and appropriate in response to a governmental order. That way, if you don't have that 48-hour notice period and you don't want to necessarily have to be concerned with relying on the emergency powers, then you've delegated that power in advance to your executive officer of your association. And again, you as a board can always take that power away later. So consider delegating some authority in the interim to deal with some quicker decisions that might need to happen.
So just some of these questions, and my apologies, I think we've addressed some of these. And if you see me, I'll try to answer kind of similar questions that we have. What do we do if we close the pool and owners still use the pool? Again, you can contact, we had this question last week, can you contact law enforcement and maybe try to say that we've issued an order on this. Here's our mandate from our community, telling people we've closed it down. If you contact law enforcement, they may come out. It depends. They may see it as a civil issue where if somebody says, well, I live here, I'm allowed to use this pool and I disagree with this rule from the board, then law enforcement might say, hey, this is a civil issue. We're not going to get involved with it. If nothing else, they might come out and say, look, even if it's a civil issue, can you guys listen to what your board is saying? And that might send the message across. We don't want to necessarily tax our law enforcement. I know that there's probably busy and addressing a lot of things going on right now, but that would be my first step. If law enforcement doesn't come out, or if it doesn't result in abatement of the issue, we kind of talked about passing a rule, maybe going through the finding process, but that doesn't stop them in the moment. So unfortunately, there's not much that you can do stopping them in the moment from something like that.
Yeah, on the back end, from a liability perspective, depending on who that person is that's using the pool, whether they're an owner, and depending on the provisions of your governing documents in terms of how it defines what rights they have, it might take them from being an invitee to a trespasser, which can change the duties you owe to that person. So if you close a facility and someone uses it anyway, we might be able to argue that they're a trespasser, and therefore you have lower duties to a trespasser under Florida law. So for example, if someone tries to sue you on the back end claiming they've contracted the virus in your community, well, if they allege that they contracted it in an area that you've closed, well, that I think makes your case even stronger if we ultimately have to see something like that on the back end.
Yeah. Clubhouse rentals, if the community is involved with the rental of the clubhouse, we've had communities that have shut that down out of concern, of course, because again, clubhouse is probably more of a closed area with lots of surfaces for people to be touching. I certainly think that that would be permissible for the association to suspend any type of planned rentals or use of the clubhouse. I think it becomes a little bit tougher, like we talked about, if you decide to close anything that's more of an open air amenity where people can maybe safely spread out, if that's the case, depending on what you might have from your county or municipality. There was a question about some type of disclaimer. I know we talked fast because we wanted to provide you all with as much information as we can. I would really work with your manager and work with your attorney on the wording of that, just to make sure we're looking at it and seeing if it provides, if it's, kind of walks the right line of providing them with information and let them know where to go and get that information, but also not saying that we're out there and that we're providing for their health and welfare. Everybody needs to be safe and take their own part. We're doing as best we can to close amenities when we feel that it's necessary because people aren't safely using them and it's a repeat issue and that we're otherwise providing information. Another question was, is the board able to cancel a scheduled monthly meeting? Yes, you're able to do that. But again, as a reminder, you want to make sure that you have them as frequently as you normally would, or maybe not as frequently, but you still have to have board meetings if you're making decisions. That's where I went into the issue of, considering the virtual board meetings as an option, check out the feedback that you get from your owners on that, if they've been able to call in, for example. And that, again, if anybody were to challenge the action taken at a virtual board meeting, I feel very good about defending it because you might not have the facility for it, and obviously you're trying to keep it from people being so close together. The other thing too is that if somebody challenges it, and if it's safe at the time to have an actual physical meeting, you could always renotice the meeting and then ratify the decision that you made, and that kind of takes away that argument. So that could be kind of a last case resort there. Another question, a question from Michael said, St. Johns County has closed the beach access. Can this be used as a reason for HOA pool closure? If you're relying on that specifically from the state statute as relying on the advice of an emergency management official, I don't know that those two are the same, but I think that it's close enough. What I understand and what I read about it, they closed it because people weren't practicing safe social distancing, basically. There are too many pictures of people being close together at the beach. That's the decision that they made it. If you say that the same thing's happening at your pools, I think you could cite to that, but I wouldn't use it as a mandate from the county. I think it would be showing where your reasoning is coming from, but I don't know that it would be, well, since the county closed the beach, we have to close our pool. I don't know that you could go that far. There's a question about revisiting the statutes on the public and private nature of HOA pools. There's nothing really so much in the statute as it is that HOA and condominium property is private property versus public property is something that the county might own or the state may own, and that they have jurisdiction and the ability to mandate whether or not, like public access to the beaches or public use of, whatever it is. So go ahead.
Yeah, and we're painting a bit of a broad brush, right? We don't know the circumstances of all your community. So let's say, for example, you sell memberships to your pool to the general public. Well, you might be taking your pool out of the private residential category. But as we sit here right now, the executive order doesn't say, from the governor in Florida, does not say that you have to shut down a pool associated with a residential dwelling. So you don't have to shut down your pools. I think it would be defensible if you decide to do that. So it's not like there's a statutory delineation between public and private pools. What we're talking about now is what the executive order from the governor right now is mandating. And it's right now, it does not mandate that pools associated with residential dwellings, it doesn't mandate that they have to be shut down. So that's kind of what we were talking more about there.
So Marshall makes a good point. If you don't want people using the basketball hoops, 4 bolts and it's done. Certainly that's a way to practically make sure that people aren't using the basketball hoops if you close that down. Another question, if your documents require an annual meeting every April, that's a good question, and that's a difficult one. I think that it's defensible to postpone it, and there's a good reason for doing it. Of course, we're in a state of emergency. a lot of communities, especially if you have 60 or 80 people, you're not going to even be able to find a physical place to have that meeting unless you found some big open space, I suppose. You know, and I'm joking about that, but I think it's permissible. But again, I would want to talk with your manager and with your attorney, if you've involved your attorney on it, as to how that information is being provided to the owners and making sure is there anything specific in your documents that might otherwise prohibit it, because there is something, I believe, in the emergency power statute says unless otherwise discussed in your documents. Now, most documents don't have an emergency power provision, but we need to look at that as well. So we want to make sure we look at that when you make a big decision like that and look at what your documents allow. Another question, if we already have a regular cleaning schedule, is the board responsible to clean and wipe down elevator and benches? Again, if you choose to do that, I don't know that you're responsible for increasing it right now. That's a tough question. If you chose to do it, I think that would certainly be within your authority. And I don't think anybody could claim that it wouldn't be a common expense that could be charged. I'm not saying that you have the obligation to do it. Again, maybe you don't advertise if you choose to increase it. But the big thing is what's being communicated to the members. That's what we've kind of been touching on today.
Yeah, and if your question is from the standpoint, do I think each individual director has a responsibility or an obligation to go wipe down equipment and things? I would say no. I mean, you as the board, you know, we'll double your salary next year for all that extra cleaning. No, but
yeah,
probably not.
Okay, so if the next question is a good one, but it's beyond the scope, I would think, and it would really require further analysis. It's regarding if you have volunteers cleaning down furniture and volunteers being covered by workers' comp. I would suggest there's some difficulties there about volunteers being covered by workers' comp and what insurance you have in place. There's a long-winded answer to that, and I'm happy to take it offline, and we'd be happy to assist or talk with your attorney if you use another attorney, but it's a little bit beyond the scope of what we have. But I want to make sure at least I address that with you, why we couldn't answer it right now.
Yeah, and there's some concerns with having volunteers do that. If you can have a vendor do that and assume some risk, that would be preferable. I mean, are you giving these volunteers PPE, for example? Are you exposing yourself to a claim by these potential volunteers that you've exposed them or exposed them to a hazardous circumstance? You know, probably get with counsel on that.
And then the next question here is, there is extended time frames for filing of tax returns. That's been pushed out how many months? I think 3 months through, I think, July. I believe the same is for annual reports. Just double check that.
Yeah.
For filing of a lot of the things that are normally required to be done by April are being pushed back, obviously, because of this. So talk with your manager about that and just be mindful of what you're able to push back. Let's see. The declaration states that 4 guests are allowed in the pool per owner. Can we declare no outside guests in the pool at this time to protect owners? Is that within the scope of an emergency board decision? It's a good question. The statute talks about if you deem property to be unsafe for use, it does talk about for tenants, owners, guests, invitees, and everything. The statute doesn't go in if you can differentiate between guests and owners, for example. And that become a difficult issue because typically guests, there's a right for guests to come in and use the amenities, or a tenant to use the amenities in the same way as an owner would. So I want to look and see what your documents provide. You know, if you're going to kick out, if you're still going to allow owners but not guests, and if they otherwise would be in compliance with your declaration, that may be subject to challenge. So again, I'd want to look at that and work it through with your attorney if you're going to be differentiating between what your documents allow versus if you're going to close it down to outside guests, for example. A good question from David here, which is, how does the board protect itself against a lawsuit regarding the virus when condo insurance doesn't cover this issue? I was told it becomes the board member's responsibility. Likely, I think it's a good point. Typically, the theory of liability, and Jim, let me know your thoughts on this, but I would think that somebody would file an action under the board, on the D&O policy, saying that the board breached its fiduciary duty or did something so out of line that you're suing the board members individually.
Yeah, and you know, so whether you have insurance to cover COVID-related claims, it's going to be policy dependent. I will say that many well, first of all, community association policies, insurance policies, particularly directors and officers liability, vary extremely widely. I don't know that I've seen 2 policies that have the exact same language. And so generally speaking, you should coordinate with counsel when you seek to procure those policies, because there are varying and widely varying degrees of coverage. One commonly included provision is the so-called pollutants exclusion. And the word pollutant is defined very, very broadly, and it could presumably include things like COVID-related claims. The bottom line is this. there is a potential for someone to, if they believe they've been exposed to COVID-19 in your premises, which obviously that's going to be a difficult proof issue, but not too hard to allege, right? If you're not covered by insurance, or your association's not covered by insurance, then, well, the association gets its money from one place, right? Is there anything you can do to legally stop someone from filing that type of claim? No. Are there things you can do to sort of mitigate or at least try to reduce your exposure, like by communicating and posting warning notices and things like that? Yes. So all we can do right now is mitigate the best we can. Is there any kind of blanket of protection we can put over your association or community? No, there isn't. And unfortunately, if you get sued or your association gets sued, and you don't have insurance coverage, then you might be in a difficult position. Now, let me talk about the association as an entity, and then you individually as a board member. No one's going to stop, nothing stops someone from trying to sue both of you, right? They're going to say, hey, the association messed up. It didn't satisfy its duty of care that we believe it has. And it might say John Smith as president didn't satisfy his duty of care in his personal capacity. Now, even if you don't have insurance to cover it, your association as a corporation might have an obligation to indemnify and defend its directors and officers. And there might be a whole process for approving that. So you in your capacity as individual director or officer, if you get sued, you might be able to look at your corporation as a source of an obligation to potentially protect you from that using, if you're not insured, assessment revenue to do that. So yes, is there potential exposure? Sure. Is there anything we can do to completely eliminate that and put a blanket of protection over community? No. Are there some difficult proof issues that we think we can foresee someone making these claims? Yes. So act reasonably, try to warn people, and you can't obviously change your insurance that you have in place right now. It might be a good time to work with your insurance agent to see what your scope is now and change it for the future. But in the meantime, just try to do some of the things that we're suggesting you work with counsel on doing and trying to protect yourself the best you can or mitigate the exposure.
All right, so we're just going to get through a couple of the final questions here, and then we'll close it down. And of course, we're happy to answer any questions offline or anything that might be more specific to your community. One is, do you require documentation of job loss if the reason given for the request is to delay HOA dues payment? If you decide to implement a procedure where you are accepting a payment plan or reducing late fees and interest, and that would be one of the qualifications. I could see that being the case if you want to make sure that it's specifically tied to the obviously the downturn in the economy and people losing their jobs. Just want to make sure that you're being uniform with all this. That's the biggest thing, so that people aren't feeling like somebody's getting a break because they know the board member versus somebody else that's required to go through a more stringent process. What if a board member is incapacitated or hospitalized due to COVID-19? It's a great question. It's obviously our thoughts would go out to them, and uncertainty is where we are right now. That it seems like we haven't seen nearly the worst of it yet. For the purposes of holding a board meeting, it almost would be like if they're not able to attend, as long as you have a quorum of the board members, you can still have a board meeting. That board member is able to call in and deem to be present. But you still want to try, if you're going to be making decisions as a board, you still have to try to have meetings, even if you decide to have a virtual one with a phone conference for people to be able to participate and listen and ask questions. Another question was, there was a vote a year ago for a big renovation. It's due to begin on April 1st. Do you advise to go forward or wait? Again, it depends on it. You probably have a lot of moving parts with that between companies that you've hired to do the work and whether or not they'll be willing to wait a little bit. If it's something that's already been going forward like that and it's not very easy to pause, I think you need to move forward with it and then decide later on if there are going to be financial issues with people repaying that. One thing that we're all still trying to get our arms around is whether or not any of these provisions for the SBA with new loans available, if those are going to be available to community associations or not. Basically, additional lending alternatives for associations. We don't know if that's going to be the case, and that's something that we'll keep an eye on. I'll talk with Lee and with Vesta so that we can communicate. And I have a lot of bankers that we work with that we can communicate generally if it's something that your community should look into. But for something like that it seems like it's been a long time coming, a big renovation project, I think it might be more difficult to stop than what you might think in terms of contractual obligations, start dates. They've got people coming out to do work, and let's deal with it. If people have issues financially on the back end, then let's look at it on a case-by-case basis.
Yeah, whoever you've been working with as your legal counsel with the $6.5 million project, which of course we know you're prudent and you've been doing, contact him or her to see, who's going to know more about your circumstances.
Yep.
And that's a good question to ask your legal counsel.
Yeah.
It's a big project, a lot of money and at issue there. So continue to coordinate with whatever attorney you've been coordinating with on that matter.
Let's see, I'm not sure of this one. All right. Does the governor's order trump a local official? Anything in state's going to be applicable, but the local municipalities can make it more restrictive than what the governor supposed. But Jim, go ahead.
Yeah, so we're dealing with a relatively unprecedented situation, and we have a lot of governmental agencies really stretching the lines of what the scope of their authority actually is. So it's tough to answer a question on such a blanket basis. There are a lot of constitutional issues that come along, that are implicated by that question. Let's say this: presume that you have to comply with both, and work with your legal counsel if you have concerns with, if there's a conflict between the two of them, because that's a really tough question to answer on a blanket basis, and it's going to depend on what exactly they try to regulate. In other words, in some instances, there's state preemption of local regulation. In other instances, the state specifically blesses more stringent regulation by both municipalities. So tough to answer on a blanket basis, but if you have concerns, coordinate with legal counsel.
If you see something that the state has issued versus if you think it conflicts with your county and you're unsure of what is going to apply, talk with legal counsel about it to make sure that you're following the best, and we can help guide you, or your legal counsel can help guide you on that. Let me go back on the stop share screen so we'll answer the last couple of questions here. Everybody should see us and Lee now, I think.
Hi, everyone.
So the Q&A will be made available for print. I need to look into that if I can provide you. The thing is, though, with the Q&A, because I'm answering them live, we don't have written answers to this, but we will have the recording that's going to be made available for the use for your community. And I know we'll communicate, Vesta will communicate that out to you of how we can make that available for you. Same thing on the next one. Let me see. What about those who wish to come to the pool to bring their own cleaning items for what they use? I don't think there's anything prohibiting people if they are using the pool, if they are keeping it open, if they want to bring their own cleaning items. I just want to make sure, I'm trying to think in normal circumstances anyways, as long as they're not bringing some type of illegal materials or something that's not available, and that might, that could trigger something in your documents about having some type of unsafe or hazardous materials or something that could be enforceable. But if somebody wants to bring their own Clorox wipes, that's all for them. I don't know that you would need to get too involved with that and anything else. Let's see. Marshall with some good questions. Thank you, Marshall. Let's see. We're a small community. Do we need to post anything about social distancing at the pool or not? Again, I don't think that that's required. I think if you chose to do that, especially if you're keeping the pool open, I think it helps send a message that we're being empathetic, we're trying to provide you with information, but you're doing so at your own risk. I think that would be the main purpose for it. So you're not required to post it. I think it would be a good idea if you had it with a sign from it, with maybe some flyers that you can find from the CDC website, that they have a couple different ones that are available. It says local sheriff of one county says private pool is closed, but not the governor. In that case, I would go by what your county did. Now, again, this is assuming that what the county did was lawful and can be applied to a private community, but under the assumption that that is correct, then I would go by what your county said in that case. Typically what I found is that, the local municipalities may be more restrictive, and as long as there's not anything prohibiting that, that would be applicable. But again, this is talk with your legal counsel to make sure if you have a question regarding it. But for something like that, my general answer would be, I think that would be a basis then for you to choose to close your pools if your county has said, if there's some type of an order from your county on it. All right, and that's the last one. Thank you for everybody for attending. Lee, did you want to have anything to help sign us off here?
No, I just wanted, Ed and Jim, thank you both. I think this has been really informative. There were a lot of questions that I was able to respond back to directly, but you guys covered a lot of bases, and I think it was incredibly helpful. For anybody that wants to do this again, we're going to do it again on Wednesday and on a Friday. We appreciate all the participants and the great questions that we got, and everybody just stay safe and stay healthy.
Yeah. All right. Thanks, everyone, and we'll be back in touch. Everybody stay safe, okay?
All right. Bye-bye.
Bye, Lee. Thanks.